Good afternoon. This is a very boring subject. So I wanted to actually show you a parody of, I don't know how many of you saw an advertisement. You know the actor Jean-Claude Van Damme, the martial arts actor? He did an advertisement for Volvo trucks to show how solid the suspension is by doing the split. So he's standing on top of two trucks. And then as the trucks move back, the trucks open up, and then he does his martial arts split. Immediately a week later, Chuck Norris, you know Chuck Norris? A 7-time world karate champion, fought with Bruce Lee in the movie Way of the Dragon, all right? Chuck Norris did a parody. He's standing on the wings of two Boeing aeroplanes with a lot of people standing on top of him, and then the planes move apart and he does a split on top of the planes. So this is a parody, and I think that's the point you were saying. If this is a parody, should it be permitted? Is that, is it something that should be a fair dealing exception or fair use? And of course, I think there is a very famous saying, what is worth copying is worth protecting. But I think that is a Western culture. Unfortunately, in Eastern culture, where most of us grew up, copying is seen as what? As an honor. So if somebody copies my work, I should be very honored because, I'm so good, somebody wants to copy my work and I shouldn't be asking for payment. So I think, because the philosophies are so different, and then we created this international copyright system, it has to balance the interests of all the different countries of the world and all the different cultures. And as Ben mentioned, therefore, you end up with a situation where you give copyright protection. Of course, you must also give limitations and exceptions so that the public can have access and will be able to use. So I'll start at the very top with the international treaty provisions and then give you 3 examples of how, from the international obligations, they are implemented in Hong Kong and Canada and then United States, and then come to a conclusion. So I think this is really the beginning of the whole issue. Article 9 of the Berne Convention, and in recent times, Article 10 of the WIPO Copyright Treaty. Article 9 says that authors shall have exclusive right in authorizing reproduction in any manner or form. So it's very clear, right? Any kind of reproduction is protected. So because it's so absolute, you have to give an exception to allow people to use. So that is where this whole exception starts with something called the 3-step test. The exception, countries can give exceptions if you meet these 3 tests. It must be a special case, first point. Okay, special case. Secondly, it does not conflict with the normal exploitation of the work, and it does not unreasonably prejudice the legitimate interests of the author. Okay, so that is the original Berne Convention passed in 1889, a long time ago. Article 10 of the WCT, which is the latest international copyright treaty, has an identical 3-step test provision for the new rights, which I think Mr. Hong was talking about earlier. I think here you call it the online transmission right. Okay. But I think in many countries they call it the communication to the public right. Okay, so similar exceptions. Meaning, let me summarize this part. It means that if any country that wants to pass an exception, you must meet the 3 tests for the reproduction right or the transmission right. Otherwise, you are in breach of your international obligations. Now, of course, Taiwan, for special reasons, cannot join the Berne Convention directly, but through the TRIPS, through WTO, Taiwan has identical obligations. Article 10 of Berne Convention, very specific. You can have certain kinds of free uses of works, quotation from published works, or you want to use it for illustrations in publications, broadcasts, or sounds or video recordings for teaching. So you see, for teaching, countries are permitted to give exception. If you are quoting, you are permitted to give exceptions, provided, again, they must be compatible with fair use, and it does not exceed the purpose that it is justified for, and you must give acknowledgement. So that is the second. So the reproduction right and communication right, very broad, 3-step rule. Here you need to meet this. 10Bs of Berne Convention for reporting of current events. So you can also use it for reporting of current events. So perhaps let's say the example that Sophie gave, if it was for reporting current events, incidental inclusion, that's fine. And then you find that for producers of recordings, as well as for performers and for broadcast organizations, the Rome Convention applies. The Rome Convention specifically sets out the kinds of exceptions you can give, with a catch-all at the end saying that you can give the same kind of exceptions as you give to authors of literary and artistic works. So I think that is the broad international framework, and that's really the framework that all countries, when you are crafting your copyright law, you have to comply, because you have international trade, you have international legal obligations that you have to follow. So let us see how different countries apply these provisions. I'm from Singapore, but now I live in Hong Kong, so I use Hong Kong as an example. And you find that the Hong Kong ordinance actually applies it almost exactly as the way the international conventions require. Very specific exceptions in Hong Kong. You can give an exception if it is for research or private purpose, Section 38, for criticism, review, news reporting, current events accompanied by acknowledgement, giving instructions in a course of study, and of course one special one that you don't find in the international treaties, but seems very, very narrow, right? For efficient administration of urgent government business. Okay, so very specific. But otherwise, if you notice these top parts, almost identical, straight out from the international treaty requirements. And then, of course, there is the provision that to decide whether, in fact, it is a fair dealing. Okay, these are the factors that the court will take into account. Purpose of the dealing, whether it's for non-profit making purpose or not. So you notice this is one consideration in deciding whether it's fair dealing. Whereas you find in Taiwan, if I recall correctly, in Taiwan law, you actually have another special exception for non-profit use. Right? So you have taken that out and created another exception. Okay? So these are just factors the court takes into account when arriving at a decision, whether it's fair dealing or not. But the primary concern the court must always bear in mind, you notice this is your 3-step test, basically, right? It must not affect the conflict with normal exploitation of work or affect the legitimate interests of copyright owners. So Hong Kong basically took the international concept, reworded it to some extent, put it into their law. Okay, so very straightforward, but actually it's a copy of the UK Copyright Act, right? So, very clear inclusions in their law. Canada, again, if you see likewise, very simple, straightforward. Fair dealing for purpose, research, blah, blah, so almost identical, if you notice. So that is another example. Then if we go to the United States, they came up with the concept of fair use. And then they capture everything under fair use, okay? And in this case, the judge made the comment. The issue of fair use is the most troublesome issue in the whole of the copyright law of the United States, okay? So the judge himself speaking. So this is the code. I won't go through the code, but you can see this is the section 107 of the US Copyright Act on fair use provision, where fair use, blah, 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 for criticism, comments, news reporting, teaching, scholarship, research is not copyright infringement. In determining whether the use made of the work is fair use, then they take into consideration all these factors. If you notice, almost similar to the provision in the Hong Kong case. But then this is the entire exception, okay, in the United States copyright law. And then let me share with you now comments that have been made over the years about the fair use provision in the United States. This is the 1976 House Judiciary Committee report. And then they say, of course, the concept of fair use has been looked at over and over again. No real definition, since the doctrine is an equitable rule of reason, and therefore each case must be decided based on its own facts, based on its own merits. Essentially case-by-case basis, all right? So that's the first conclusion. So these are examples of the cases that have gone before the US Supreme Court and the kind of finding. And that's why actually I wanted to share with you the parody. It's a fantastic parody. Google it, you can see it. Here, parody of a TV program of a motion picture. The court actually came to a deadlock, 4-4. Okay, the Supreme Court. So they couldn't agree at the highest level whether it was a fair use or not. Photocopying of scholarly articles by a federal government library, 4-4, lockdown, okay, at the highest level. Videotaping of over-the-air TV programs for purposes of time shifting. You know, in the old days, right, you have no control over the TV program. So if you have to work late, you know, you get somebody to videotape it so that you can come back to watch it in the night or tomorrow. Time shifting is considered fair use, 5-4. The court decided. Magazine published about 300 words from former President Ford's soon-to-be-published memoir. 300 words, huh? Not fair use, 6-3. Okay, the courts decided. Making a motion picture based on a short story, not fair use, 6-3. Rap of Roy Orbison's Oh Pretty Woman. I was trying to get that rap, but somehow it wouldn't play. Fair use, okay? So these are just some examples of how the courts arrive at a different decision. Now let me share with you what commentators have said over the years. Fair use concept is hopelessly unpredictable, okay? Okay? Exceedingly difficult to predict whether it will be a fair use or not. David Niemer, who is, if you are practicing copyright law, you know Niemer on copyright, very famous, concluded in his comprehensive study to say that, again, reliance on the factors to reach fair use decision often seems not but a fairy tale. Okay, in other words, impossible. Okay, Larry Lessig, most of you will know him, right? He's the one who came up with Creative Commons. So technically, actually, you can say he's anti-copyright, so to speak. Even he comes to the conclusion the fair use provision is essentially, it boils down to the right to hire a lawyer. Because once you want to talk about fair use, you need a lawyer. Because nobody can advise you on whether you have a fair use or not. Okay? So courts have joined the chorus. Okay? So judges themselves are saying, right? The doctrine is so flexible as to defy definition. You cannot define what is fair use. Okay? So that finally, it is rough justice. Okay? Rough justice meaning, it's basically, you take a coin out of your pocket, okay, you win. All right? That's it. That's rough justice. So these are US scholars speaking. Right? So I felt I had to share this with you because to let you appreciate how the Americans themselves, and it's a pity our American friend left. Perhaps he would have a word or two to share with us. But, the concept is a very, very difficult concept. And I found it interesting that the Taiwanese copyright law actually uses both approaches. So you actually have a fair use concept to capture everything else that you do not specify. I mean, my one comment, of course, standing from copyright owner's point of view, it probably unfairly tilts the balance in favor of users, right? Because the Americans have fair use. The British, Hong Kong, the common law, they have this other system. But you have brought both systems together. So, you know, it is really, I would say, very much in favor of users rather than copyright owners, right? So, quick summary. As far as fair dealing is concerned. So unlike fair use, fair dealing, the purpose of fair dealing is simply, is defined, is limited. So if you are not criticizing, if you're not reporting current events for teaching, not for private study, you don't qualify, okay? That's it. Fair use, on the other hand, is not defined or limited. And the court has discretion to decide what to do or how to conclude. If you want to change the fair dealing arrangements, let's say in Hong Kong or in Canada, you need legislative change. And of course, to do legislative change, you need public consultation, and then interests of stakeholders can be consulted of, like what you are doing now, right? I think that is something which is occurring now. It also, the concept of fair use is defined, is certain. So it's either teaching, it is private study, it is for reporting current events. There is no, you know, ambiguous concept of whether it is fair use or not fair use. So my conclusion is, I think it is, from my perspective, definitely better to adopt, say, what Hong Kong or Canada and Malaysia, Singapore has done, because it's clear, it's certain. Whereas if you use the concept of fair use, I think it will really create a very uncertain situation, plus lead to a lot more litigation. And some of my American lawyer friends actually always joked that they survive from litigating, copyright lawyers, from litigating fair use cases, because, you know, you make a lot of money, people are always fighting. And especially in today where you go online, you see a lot of parodies, you see a lot of UGCs and so on, right? And I didn't want to talk about UGC, but since Sophie mentioned it in her presentation, I thought I should just conclude with a couple of words on UGC, user-generated content. From right owner's perspective, we already give licenses for UGCs. So record labels have license, for example, YouTube, so that under certain conditions, you are permitted to use the musical works or the recordings for making user-generated content. So we believe that the existing system with the licenses that right owners are giving is sufficient to cater to the situation of UGC. So far, the only country in the world that has a UGC exception is Canada. And there are questions as to whether, in fact, that exemption is breaking Canada's obligations under the international treaties. In Hong Kong, and my friend from Hong Kong, two friends from Hong Kong are here, they can advise you. There has been a debate going on for quite some time about a UGC exception. And in the latest proposal before the Hong Kong LegCo, the government has not provided for UGC exception, indicating, like what I've just said, that they believe that current exceptions and licensing arrangements are sufficient to cater to it. But we do expect some segment of Hong Kong to become very vocal within the coming months to try to push for a UGC exception. So my concluding words on this point, please do not introduce a UGC exception, because we believe, you know, the situation is well catered for. Thank you very much.